Welcome to All Things Financial with Jack Driscoll.
Welcome back, everyone, to another edition of All Things Financial. Appreciate your tuning in and watching on TV. I have a guest with me the last couple weeks, Colin Morgan from Julian Gray Associates. Thanks again for coming on.
Thanks for having me.
What we're doing is an ongoing series, actually, of legal planning for regular families, legal planning for people with disabilities, legal planning for retirement and nursing homes and the whole gamut. And we've reached this stage now where I wanted to talk to you a little bit, Colin, about one of the specializations of your firm and yourself, which is planning for if one of our relatives or loved ones has to go into a nursing home, or it's likely that they might, or they're showing signs. How do we deal with that issue?
Okay. And I think, looking at it from, when do I first come in, or what do we do when everybody's fine and I'm still working, all the way up until, what do I do, if somebody's in a nursing home and they're, not coming home. I think that looking at it from soup to nuts, from A to Z is a good idea here. And so I think, my young clients who come in, the guys and the gals in their 30s and 40s, who are coming in, maybe they're just married and they just have some kids, we're going to look at last will and testaments, healthcare powers of attorney, financial powers of attorney. Those are very important and vital documents. If they have accumulated wealth at that point, which I hope they all have, that'd be great for everybody, we're going to look at revocable living trusts. I think that's a very good, start. That's your foundation. That's where you build from there. Okay. And at that point, we also look at the family. We see, do we see something down the road for mom or dad? Is there a history of Parkinson's or health disease or heart disease or something like that? Do we look at some planning there? Is there a diagnosis? Are one of my clients' children disabled? Are they on benefits programs themselves? And we talked about that in an earlier segment. Let's make sure that those family individuals are taken care of properly from a legal perspective. And we also want to, if they haven't already, we want to look at products like life insurance or long-term care insurance, because when you're in your 40s and 50s, you're really in the sweet spot, for those types of investments. And so that's a good first step, And so what we want to look at after that is when you reach a certain age where you're starting to consider retirement, where you're no longer going to be in, contributing mode to your, IRAs or qualified plans, where you're going to be in more of a drawdown mode.
Right.
We want to make sure that you have the proper legal documents in place at that point. We'd like to revisit the last will and testament because your kids are probably grown. Okay. We don't need those provisions that were in there before. We want to revisit your healthcare power of attorney, your financial power of attorney, because we might be putting generation 2 in as fiduciaries as well. Because sometimes it's a toss up. If mom and dad appoint each other as their agents under power of attorney, well, if you both get sick, who's going to take over? So we want to get that whole depth chart. Also, we're going to look at higher caliber trusts. On top of the revocable living trust, we want to see if there are significant qualified resources. We want to shade in the IRA trust that we talked about in an earlier segment. And then we want to look at, probability of health need in the future. And if there's a great probability or higher probability, we want to add things like, an asset protection trust into the plan to start protecting the house, the life insurance, the long-term investments that nobody is drawing on. Now, what happens after that is maybe somebody starts to get sick. The early stages of dementia, maybe somebody's diabetic and they're, getting treatment from that perspective. And maybe it's not a high cost, situation. Maybe they're just having a little help. So now we want to put more resources into the asset protection trust. We want to start looking at how we're going to address the IRA, because an IRA is a very exposed asset. Now, long-term care insurance helps with that. Hedging life insurance helps with that as well. And we also want to engage, some healthcare professionals. Now, our office, something that sets us apart from many law firms, is that we have on staff social workers.
Wow.
Yeah. And we found that, well, attorneys are blunt objects, okay? We kick in doors and we get stuff for our clients. That's our goal.
Right.
That's our job. We might not be, the best bedside manner, and we might also not be the most knowledgeable when it comes to clinical cons. At that point, that we have somebody who is savvy to those things, but more importantly, is our client's advocate.
Okay.
Every hospital has social workers. Every nursing home has social workers. Mm-hmm. The problem is, and they're great people, they're great to work with, and they do a wonderful job, but they're not our clients' advocates. Okay, they're advocates for where they work. So we want to get our own professionals in. So maybe at that point we introduce a social worker who talks about things like day programs, Meals on Wheels, Access, all those programs that we've set up, through our government, although there have been some cuts, but they're still there, a lot of them, to help make life easier for people as they age. So there's that, we don't need a lot of care. Okay, but we still need enough, or we need good resources out there. After that, perhaps a person has suffered a medical event, or they're starting to decline, or their disease is starting to progress. And now we're looking at more of a care setting. We're looking at an assisted living facility, or, a personal care home, or a memory care unit. So what happens here is we're spending a lot more money. Okay, at this point, we're bringing people into the house. We're putting $5,000 a month into a facility. So we need to look at what benefits programs are out there. Primary among those, like we talked about in our last segment, that's the Veterans Affairs benefit. We have a great tradition in Western Pennsylvania of veteran service, and a lot of armed service members in our area. So a lot of these folks can get a lot of help from the VA. So we want to look at qualifying people for those. If they don't qualify for Veterans Affairs benefits, if they're like me and they worked at a summer camp or a video store when their buddies were going off, we look at other things. We look at recharacterizing their assets. We look at working with a financial planner to maybe create more liquidity in their name so they can intelligently spend their resources to stay and get the care that they need. And that's fine. I mean, that's what the vast majority of my clients' children don't want their parents' money. They want to make sure mom and dad are receiving the right medical care. Mm-hmm. So that's kind of the fine line that we strike. Oftentimes, because our clients say, well, we want as much money as possible to go to our kids, and the kids are saying we want the best care possible for the parents.
Right.
And so we need to look out for their best interest. And so getting the best care possible is that best interest. So that's where we look at other benefits programs that might be out there, through the Area Agency on Aging, that are, just programs out there to help get people into day programs and things like that. Just looking at as many resources as humanly possible, even if we can't get a person onto Veterans Affairs benefits. Lastly, and the last step, in the elder care journey is normally, a nursing home, a skilled nursing facility.
Right.
That's where medical care is so high, and there's so much need there that a person is basically 24/7, under observation. At that point, we look at medical assistance benefits. Medical assistance benefits, just like the VA benefit, is a means-based benefits program, which means you have to have under a certain amount of money to get onto it.
Okay.
And we have to take more drastic measures at that point to get a person onto these benefits programs. Now, if they started working with me when they were in their 30s or 40s, we have all this amazing framework in place. We have, stratified trust starting, with the most open up to the most restrictive and most qualified for benefits programs. So hopefully we have all that in place. So all we're doing is saying, great, we'll do the application for you and we'll float you right on. However, the vast majority of my medical assistance clients come in, they've never talked to a lawyer before.
Okay.
And good for them. Who wants to talk to lawyers? But when they come to my office, you have to take much more drastic planning measures at that point.
Okay.
We're looking at spending down resources. We're looking at doing strategic gifting to other family members. Sometimes you gift half of everything, okay, and then you use the other half to pay through, whatever penalty period that the county says you have to pay for, by giving those gifts, things like that,
Okay.
Lots of different planning measures.
That's complex. Now, let me ask you this. When you said nursing home and skilled nursing homes, is it a problem sometimes if a family member puts a parent into an assisted living facility that then when they need access to a nursing home, isn't Medicaid eligible?
Yeah, and that's a good question. So actually, in the state of Pennsylvania, assisted living facilities are supposed to be covered by medical assistance. That law was passed years ago. Guess what? We haven't funded it yet. So, you have to, part of, my specialty and part of our body of work at my firm is recognizing these situations and planning accordingly. If you're working with somebody who doesn't know what they're doing, they'll say, yeah, we'll send in a medical assistance application that might not even be necessary because they're not going to pay. So you need to make sure that you have a good balance of having the right care setting for the individual, having the right income in place, and also having the assets characterized properly.
So you try to structure that with your firm and you, guidance in advance before making the applications?
Absolutely, and we take a real multidisciplinary approach. So, gone are the days where the lawyer just did 100% of everything for a client, and same goes with the CPA, and same goes with the financial planner. To get it done properly, I have to have an engaged CPA and an engaged, savvy financial advisor, because we all have to work well together. Mm-hmm. And so that's a lot of the main message that I plug when I teach classes and I deliver seminars and go on a program like this is we need to make sure that all your ducks are in a line as far as your professionals are concerned too. Mm-hmm. What is concerning to me sometimes is where I have a client who is in one of the 1-800 number, financial planning things. So they go, well, it was really cheap, and they didn't lose us a ton of money, so it made sense at the time. Well, I go, well, how do we get the right product? So I have to transition somebody to professional who works. Mm-hmm. Same goes with the CPA. So, I could set up a great, perfect trust plan, okay, and they could lose a lot of money in the market. Why do we even do it? Right. Furthermore, a financial advisor could be as conservative and savvy as possible and has nothing but growth for their client. But if they go to a nursing home without any planning,
right,
you just have more money to pay the nursing home at that point. So it's so important to plan early, and it's so important to utilize all the people who know what they're doing, at an early stage.
Now, what's this that I keep hearing about? A lot of people feel the 5-year, we keep hearing 5 years, 5 years, 5 years. If you didn't do it by 5 years and all that, can you get into that a little bit for us?
Sure.
On the timetable of this planning?
Absolutely. So, the 5-year look-back period, if I ask a potential client, what buzzwords do you know from our industry? Right. They're going to say the 5-year look-back period. Right. I need to put this money in, and it's funny, they say if I put this money in trust, I need to not die for 5 years, right? Mm-hmm. And I go, well, you're almost right, okay, with what you're saying. It's not about when you pass away, it's about when you have medical need. So when you use a qualified trust or you gift assets, okay, for planning purposes, mm-hmm. if you're trying to remove assets from your estate, right, for Medicaid planning purposes, you need to do it, to get it done perfectly, it needs to be at least 5 years before you apply.
Okay.
Because what happens is, say I go into a skilled nursing facility, the county, okay, is going to look back 5 years in my financial history.
Okay.
And every transaction that I make that's for less than fair market value, which means a gift to a child or somebody else or a transfer to a trust, is going to be counted against me.
Okay.
And so what that means is, every dollar that I give builds up what's called a penalty period. Mm-hmm. So basically the county looks at the total amount of gifts that you've given over the 5-year period and divides it by what they perceive as a monthly average in a nursing home. And whatever factor comes out of that equation is how long you have to pay out of pocket. So, if you've made a $500,000 gift right before you go into the nursing home, that's a big time problem.
Yeah.
So if you can get done, before that 5 years, that's the best. That's, as copacetic as it can get. I love those plans because, the client gets the most growth. The client gets to keep the most, and it's the easiest application for me because I'm given a goose egg on the asset, on the asset list going into the facility because it's all out as far as medical assistance is concerned. But we look at a lot of different planning tools. So a lot of my clients are individuals who have had a diagnosis or who might be rather high in age. Okay, when they come to my office, so maybe the 5 years isn't necessarily in the cards to them. They go, well, what happens? Why do I even do this plan? What happens if 3 years from now I go into a skilled nursing facility? Yeah. So we look at the cash flow at that point. The first part of the analysis is, does it make sense to pay through the remaining of the 5 years? Okay,
Wow.
and then just get there.
Yeah.
If you have $500,000 sitting in a trust, and you have, $30,000 or $40,000 of exposure, well, maybe it makes sense to just pay out of pocket and then send that nice clean application in.
Yeah.
Other times it makes sense just pull all the money back out of the trust and do a spend down plan like we talked to. Gifts to disabled children are not countable for medical assistance. So if it makes sense, and you'd have to use trust, you'd have to make sure that it makes sense from that individual, the child's planning perspective. Other situations, living caretaker children, can take over the house if they've been caretakers for more than 2 years.
Wow.
We see a lot of cases where people leave their jobs to take care of mom and dad.
Right.
And we need to make sure that those people aren't homeless. At the end of the day, that's something that the medical assistance program has afforded. For those families, and also siblings with equity. We're Pittsburghers. We know. There are always those two aunts or those two uncles that have lived together for 60 years and they never got married. They never had kids.
Right.
And if they're living together, they can also take over the house, because it's not medical assistance goal to leave people, to leave family members impoverished and homeless. So we need to make sure that we're utilizing, all the planning techniques and tools that we have.
Okay. Now, what about the spouse? You've got the spouse. How are they protected? Can they be protected? I know the Spousal Impoverishment Protection Act,
Right.
1989, and all that. And then also, can you touch on the estate recovery provisions?
Sure, absolutely. It's a very good question. So there are some protections built into medical assistance law. First off, a healthy spouse, his or her IRA is not countable toward that whole spend down equation.
Wow.
So that's a powerful thing that not a lot of people understand. They go, well, I'm going to lose my entire IRA because my husband's in a skilled nursing facility. No, you're not. It's safe.
Wow.
The house is also not countable. So one of the first things we do with all of our married couples who are applying for medical assistance is we transfer that house from the couple to the healthy spouse's name. So we need to get that out. And that's for estate recovery. We'll talk about that in a moment. And then everything else, the countable estate, is divided in half. So half goes right off the table. So half is protected. The other half is what we use those spend down techniques, the spousal annuity that we talked about, the irrevocable burial accounts. Those things, we want to get value out of that spend down. For the person. And oftentimes a lot of that money goes right into the house, because a lot of people are frugal. And maybe the roof needs to be replaced. And they thought, well, I can't afford that. Well, now's the time to get that roof fixed. Now's the time to get that new driveway, that new hot water heater, the backup hot water heater, all that stuff. So we buy all those things. Lastly, the Estate Recovery Act, and that's a very good question. And that's kind of, when somebody's more savvy, about medical assistance, they ask, well, what about estate recovery? So when you're a medical assistance recipient, so say I'm on for years, and I pass away, the Commonwealth has racked up, like a tab, against me. So however much they've spent on me, they're going to try to recoup from my estate. So we need to make sure that there's no money in the Medicaid recipient's estate upon his or her passing.
And is that the probatable estate?
Just the probate estate. So the wonderful thing about using our trust isn't a probate asset. Everything in the trust goes outside of estate recovery. Nothing can happen there.
So it not only protects it during that term, but it protects after all.
Absolutely.
Both spouses are gone.
And it could be multi-generational planning too.
Very good.
So this can be a Medicaid compliant trust for generation too. So you don't need a 5-year look back period because it never touches the person's name.
I see.
So there's a lot of planning there. But from an estate planning perspective, what you have to do is make sure that the beneficiary designations on the individuals, in their assets, the Medicaid recipient, make sure that it's not going to go to that person's estate. Furthermore, you have to make sure, and this might sound harsh, but you have to make sure that that person has been, disinherited by everybody else, because the worst thing you can do is leave a medical assistance recipient, $10,000.
Oh, that's a good point.
Yeah, and we've seen it happen a lot. I get a lot of, cases that are totally avoidable. The family calls me and they go, my great aunt just passed away and she left, my mom at the nursing home $20,000. What the heck do we do? She just lost her Medicaid.
Wow.
So that's a big deal too.
Okay.
So we'll make sure that's all in line.
Yeah, that's something we wouldn't think about.
Well, that's what
nobody
lawyers are neurotic
thinks like
people,
that.
you know.
Yeah,
This is
yeah.
this is the kind of things you think about around 2:00 in the morning when you're going through your client role and you go, okay, what do we do for this person? So
That's got to be the strongest point, I have to say, because Colin deals in this day in and day out. So while all the rest of us are out golfing and fishing and spending time with our grandkids and our children, and we're so busy in life, while we could think of these things, Colin is doing nothing but thinking of things in this area. So what you just pointed out at 2 a.m. and you're waking up thinking about this, that's why we need qualified, skilled professionals like Colin to help guide us through preventable mistakes and errors that we would otherwise be making.
Thank you.
I appreciate your coming in very much, Colin.
Thanks for the opportunity.
Colin, can you help everyone listening and watching on how to get a hold of you?
Absolutely. So there are 3 great ways to get in touch with us. First off, you can visit our website. That's grayelderlaw.com. Secondly, you can email me directly. That's Colin, Colin, at grayelderlaw.com. Or you can give us a call at our front office. That's 412-458-6000. And what will happen at that point is you'll talk to our triage staff, who they're absolute experts. They know more than most people, more than a lot of attorneys about what we do. And they'll get a lot of good information for me, okay, so I can start to formulate a plan proposal. And we'll have you in for a no-risk consultation. That means that if you decide that, not go with us, or if I decide that you don't need our services, then it's not going to cost you anything. So we think that creates a really good open relationship, with the firm right off the bat. So basically those are 3 ways to get in touch, and if you need us, we're always around, so feel free to give a call or email. Thank you.
You've been listening to All Things Financial with your friend with the answers to all financial matters, Jack Driscoll of Driscoll Insurance and Financial Services. Securities and investment advisory services offered through Sage Point Financial Incorporated, a registered broker-dealer and registered investment advisor and member FINRA and SIPC. Driscoll Insurance and Financial Services is not affiliated with Sage Point Financial, Inc. or registered as a broker, dealer, or investment advisor. You can reach Driscoll Insurance and Financial Services Incorporated at 412-833-1500, and they are located at 2738 South Park Road, Bethel Park, Pennsylvania, 15102.